start by introducing myself. My name is Hillary Cascade. I'm the founder of Parents Against Baker Acting Children for Charlotte County. The reason that I started this group is because right after the very tragic school shooting in Parkland in February, the first thing that happened was Scott Israel went on television, Sheriff Israel, and immediately started calling for more Baker Act powers. To me, this is extremely frightening. The Baker Act is already abused. It is misused. It is not used as intended, especially when it comes to children. Solon? Now, one of the main things I want to go over is exactly what the Baker Act is. For the state of Florida, the Baker Act is the Florida Mental Health Act, Florida Statute, Chapter 394. It covers all aspects of mental health care in Florida, voluntary admissions as well as involuntary admissions. It covers who is able to provide services such as crisis stabilization units and short-term residential treatment facilities. The Baker Act is supposed to protect the rights of all individuals, providing due process, whereas before its introduction in 1971, there was very little due process for people committed to mental health facilities. An involuntary examination, or Baker Act, can be initiated in one of three ways: by police, by a licensed professional, or by a judge in an ex parte motion. Solon? Now, when it comes to initiation of the Baker Act, law enforcement does more than 50%. Mental health professionals are responsible for just under 50%, and the courts do under 2% of all Baker Act initiations. In order to meet criteria to be Baker Acted, you must A, have a mental illness, or at least appear to have a mental illness. You must present a danger both to either to yourself or to others in the public. And you must refuse a voluntary exam or be unable to understand the reason why an exam is necessary. Now, what is supposed to happen is that it's supposed to focus on stabilizing the immediate crisis. Supposedly within 72 hours of placement, they have to decide what to do with you. They either have to release you or keep you. The 72-hour time frame is actually how long they have to go in front of a judge and file their motion. The actual average length of a Baker Act stay is 4.5 days. In most of these facilities, that's roughly $1,000 a day that you will be charged. Release must be approved by a psychologist or a psychiatrist. Just to draw attention to those